On a very light note, I just pinched myself 1 second after seeing two of my classmates in there. And 3 students. And these 3 students will be bringing to the fore issues that circulate in our system and affect our society, and issues that become topical, especially when they have to do with their relation to the law. Please permit me to welcome here Nehume Japong, who will be the students segment moderator. Edward Adiaba, who is a member of the graduating class, Shall we do a big round of applause as we welcome them?
My lords, permits me to stand on all existing protocols. In 5 minutes, 2 students, Edward and Lord, of the graduating class of 2026, would give their views on whether morality should influence the law, and if it should, to what extent. More specifically, on the anti-LGBTQ bill currently in Parliament. Well, we can't really tell if it's in Parliament or it's out of Parliament at this point. So we would have Edward Adiaba speak first, and he is in favor of the anti-LGBTQ bill. Edward.
Justices, Dean, invited guests, fellow colleagues. I just want to thank the organizers of this program for the opportunity to stand up here and talk on a very controversial topic. And I just want to point out that these are basically my views and thoughts. They are not crazy thoughts, but they are worth discussing, okay? So the topic of LGBTQ plus and other related issues in Ghana, I feel that, allow me to borrow the argument of Patrick Devlin, okay? He talked about a shared morality that we as a community must have. And it is that shared morality and that particular argument that I'll be basing my opinions on. So, as we know, the religious demographic of Ghana, if you look at the statistics, it basically outlines the fact that Ghana is mostly a religious state. Most of the population is religious, Christian, Muslim, traditionalist, all that. So the baseline, is the shared morality of the Ghanaian people. The former dean, who is now the director of legal education, Professor Raymond Atuguba, he did write an article on that. But his main concern was that, one of the main concerns in the article was that the rights of the people, even though they are protected in the Constitution, is not being advanced. He categorized it as state-sponsored homophobia, in the sense that some political, agents were trying to garner hatred towards that community. Now, before I continue, I just want to give a basic assumption of. I just want to give the basis upon which I'm stating this. For me, I believe that if there's any regulation of the law, it should be to protect the persons as humans, but prohibit the act. Because, like I stated earlier, the shared morality of us Ghanaians does not, allow for LGBTQ plus related activities to go on. And this has been attempted to be done by the bill. And it could be perfect, though, because it criminalizes the act of engaging in sexual related activities, but it ensures that the victims and the accused persons and the convicted persons are protected because they are humans. Aside from the fact that they are humans, which are deserving of right, it is the act that is being prohibited. So I am for the LGBTQ plus law. I believe that it's a step in the right direction because it's promoting the values that we as Ghanaians hold. Even though the bill work can be done on the bill, but it is a good attempt, and discussion should be made on perfecting it and protecting the individuals rather than. Thank you very much.
Seeing as our time is almost spent, Lord would also present on why he's against the anti-LGBTQ bill in 1 minute and 10 seconds.
Good afternoon, everyone. So very quickly, I'll respond to Mr. Edwards' contention that Ghana is a religious state, and for this reason, religion should dictate the tenets of the law. I believe every student of the University of Ghana School of Law knows that Professor Kwashiga teaches that Ghana is a secular state, and despite the fact that some 70% of Ghanaians are Christian and the majority of others are traditionalists and Muslim, this does not render Ghana religious. And for this reason, I do not think it is reasonable to use religion as the rationale to legitimize homophobia against minorities in Ghana. And further, I would like to touch on 3 provisions in the colloquially called anti-LGBT rights bill. Now, Section 3.2 prohibits parents, artists, teachers, and other professions and other individuals from discussing certain concepts deemed anti-traditional family values to children and other students and all other persons. And I believe that this infringes on certain rights. Firstly, the parental rights and the right of parents to decide what to teach their children and how to teach their children. This infringes on the rights of lecturers to teach, which is academic freedom. And I believe that for this reason, Section 3.2 does not really advance the courses that we want to advance in this country. And further, Section 5 on the duties to report their friends, their family, their students, and all sorts of people to the government and the authorities for prosecution. And in some instances, these persons may face prosecution themselves if they refuse to report. And lastly, and most important to me, is Section 23, which provides that persons who may be undergoing certain intersex feelings and beliefs should undergo what we could call conversion therapy. And we know from academia outside Ghana and even by some professionals within Ghana that conversion therapy is dangerous and offers no real benefit to people, and in some instances can lead to suicide, suicidal ideation, and other problems. And so for these reasons, I believe that the anti-LGBT bill is not fit for purpose in Ghana. Thank you.
My lords, distinguished ladies and gentlemen, those are the thoughts of our students, and we leave it to linger on the minds of everybody. Thank you very much for this opportunity.
Ladies and gentlemen of distinguished measure, before the introduction of our first speaker, it's my pleasure to acknowledge the presence of the Vice President of the Greater Accra Bar Association under the Ghana Bar Association, Mr. Andrew Apalbing. Shall we do a big round of applause? He's also the senior partner for Stobe Law. We're very grateful to you, sir, for the support. Thank you. Distinguished ladies and gentlemen, as I mentioned earlier, we're here gaining great support from some senior lecturers and lecturers of the University of Ghana School of Law. My pleasure to acknowledge the presence of Dr. Roland Atta Kesson. Shall we do a big round of applause for him? And of course, my lord, my lady, with your permission, I thought that I like to impose St. Augustine's College on everyone else until I met Dr. Roland Atta Kesson. Yeah. But you know, on a more serious note, with the greatest permission, I believe that omnia vincit labor applies to every single motto of every educational institution. Perseverance conquers all. So please apply it to your institution, and you'd realize that Dr. Roland Atta Kesson may have a point after all. Please do a big round of applause for him one more time. Also, we're glad to have the presence of Dr. Laurentia Opong-Pepra. Shall we do a big round of applause? Of course, Dr. Augustine Kidisil. A big round of applause, ladies and gentlemen. Also, ladies and gentlemen, I acknowledge the presence of Mr. Kenneth Gotti. A big round of applause. We'll do some more acknowledgements as we go along, since today is a day of to get to know better one of our two speakers for this evening. I'd like to welcome up here one of us. One of us in the sense of an achiever who is a member of the winning team of the 150th anniversary of the Supreme Court of Ghana Moot Court competition. Please help me welcome Winfred Senam King.
Your Lordships, permit me to stand on existing protocols. It is an honor to stand before you today to introduce a man whose career has spanned the courtroom, the classroom, and the international stage. His Lordship Justice Sir Dennis Dominic Ejay is a Justice of the Supreme Court of Ghana. He also serves as one of the 11 judges of the African Court on Human and People's Rights in Arusha, Tanzania, and is a Fellow of the Ghana Academy of Arts and Sciences. His Lordship Justice Dennis Ejay was, until 22nd of April 2026, a Fellow of the Centre for International Mediators and Arbitrators of England and Wales. On that date, a new tier of senior fellowship was created, reserved for only the most prominent and highly esteemed justices in the field, and he was among the few selected to receive it, and today holds the rank of senior fellow. He was also elected to the Inns Court of Judicial Fellowship for senior judges in common law jurisdictions for the 2022 to 2023 academic year, making him the second African to hold that position. He chairs the Independent Examination Committee, the body responsible for examining legal education in Ghana. He is also one of 18 experts on the African Union Committee of Experts on Reparations. He attended the University of Ghana and completed his studies in 1991. He entered the Ghana School of Law in that same year and was called to the bar in 1993. He went on to earn an Executive Master's in Public Administration from the Ghana Institute of Management and Public Administration, GIMPA, Accra. He also obtained a postgraduate certificate, a postgraduate diploma, and the Masters of Laws in Criminology and Criminal Justice from the University of London. He further holds a Master of Judicial Studies from Duke Law School in North Carolina, USA. He was one of the nine-member advisory committee of the International Criminal Court at The Hague, and became the founding chairperson of the African Judicial Network on Environmental Law, headquartered in Nairobi. He founded the Holy Trinity Chambers in Kumasi, and he practiced in Kumasi and rose to become president of the Ashanti. He was the president for the Association of Magistrates and Judges in Ghana for 2 terms. He was also the supervising judge for Western and Central regions, Ashanti region, Bono Ahafo, and the northern part of Ghana. He has served on several departments and directorates at the Judicial Service, including the Chairman for Public Complaints and Inspectorate of the Judicial Service, Chairman of Appeal Records, Chairman of Private Process Service, and co-opted member of the Rules of Court Committee. He was also the first president of the Court of Appeal in Tamale, Ho, and Koforidua. He has published 7 textbooks and co-authored the 8th. He has also published extensively in peer-reviewed journals in both national and international levels. He has also published extensively in journals, made several presentations nationally and internationally. He is a former director of the Judicial Training Institute in Ghana and has served in several leadership and administrative positions in the Judicial Service of Ghana. He is the former director of the Judicial Training Institute, a former dean of the Faculty of Law at GIMPA, and a senior lecturer at the Ghana School of Law, where he heads the Faculty of Interpretation and Deeds and Statutes. He holds adjunct professorships at the University of Cape Coast and Accra Metropolitan University, and serves as an associate professor, part-time, at the Kwame Nkrumah University of Science and Technology. And in 2005, Pope Benedict XVI knighted him into the Order of St. Gregory the Great. It is with great honor that I invite you all to rise and join me in welcoming His Lordship, Justice Sir Dennis Dominic Ejeri.
Munyana ho mame. Abla no ti so enipa yo wodi ne ebo nipa ya de nso a osaye yie aje kwade Mone nkodene sa ya shemu a odwuma pa na ato nsafra wo ifiri se ye nipa bedua o ano betwa Ghana do ase washa suampan ya nuenyam mebi aso amanone Enti nadia ya tonsa fransa bani ameso anunyam enti brana bekasa na ya tonsa framesa me fase pewa mejo tata ajei kwadie ajano makwalie blesia mo betua ne takra mo ablejabum be mena wudi no honam se enti menensa bra atonsa frawo Kasao na ganetia wo.
Saying that I will stand by the existing protocol, and I don't want to be a deviant, and I should also follow suit. Dean, I believe I'm permitted to do so. And my brother Kulendi, asked him, he has agreed. Because he cannot say no. All right, good evening. I've been here to share some few thoughts on the evolution of Ghana's legal education regime and the way forward. And I'm going to look at it from 4 thematic areas. The first one, the passage of the Legal Practitioners Ordinance of 1876 and qualifications for barristers and solicitors in the colony. Colony means at that time. The Legal Profession Ordinance of 1944 and qualifications for barristers and solicitors in the colony. Then 3, the legal training after independence. Then the last one will be the basis for the change by the Legal Education Act 2026, Act 1170. Then I conclude. I would say that law is the architecture of society's justice, reflecting its history, defining its present, and shaping its future. From the shores of the pre-colonial Gold Coast, where customary adjudication thrived under traditional rulers and castle governors, administered justice under the merchant and naval laws, to the modern era of statutory frameworks and codified governance, Ghana's legal journey has been one of continuous transformation. The story of the legal education in Ghana is not merely an account of statutes, ordinances, and institutional mandate. It is the chronicle of a nation's enduring quest to define, localize, and elevate the administration of justice. The recent passage of the Legal Education Act 2026, Act 1170, marks a watershed moment, dismantling the long-standing monopolies, re-engineering professional training, and introducing the National Bar Examination. So when I heard that some LLB graduates are coming out and they are going to undertake pre-bar, I said, you were lucky. You should have come under my mandate, because you should have been called to write the entrance examination. But unfortunately, the power has been taken away from me. Colonization had a direct link with legal practice in Ghana, and until 1874, when the British colonized the Gold Coast and became a crown colony, there were no legal practitioners in the Gold Coast. During the merchant era, between 1482 and 1874, there were no formal lawyers in Ghana. And the governors, those who practiced law, they were the governors, castle commanders, British merchants. They administered justice in accordance with merchant laws and naval laws, and the customs of the forts, because they live in the forts. And the forts were set up by the Portuguese, Dutch, Danish, and the British. There were no trained lawyers at that time in the Gold Coast. But we had the chiefs, elders, and queen mothers administered justice in accordance with native customs, taboos, and precedents from elders in dispute involving the peoples of the Gold Coast. At times people ask, what were the precedents at that time? There were that if you insulted a chief, your tongue should be cut off. Yes. The linguists spoke for the parties involved, and that marked the origin of representation within the traditional system of adjudication. The Supreme Court of Ordinance of 1876 established the Supreme Court of Gold Coast and introduced English law following the declaration of Gold Coast as a colony. We all know that when the British came, they started trading with us. Then at a point in time, they said, we were protecting you. Then in 1874, they said, we are no more protecting you, we are colonizing you. The decisions of the Supreme Court were appealed. That is, the Supreme Court with both original and appellate jurisdiction, which we are celebrating 150th anniversary of the court today, and this evening they are having the dinner to semi-crown it, because the crowning event comes on tomorrow with church service. From there, you appeal to the WACA, the West African Court of Appeal, then with leave to the Privy Council, which was located in England. Before the passage of the Supreme Court Ordinance of 1876, some people described themselves as attorneys. Nobody appointed them, but they called themselves attorneys. By making representations in the courts, they have those orators and those who are well-versed with customs. So they would put up themselves as representing people before the chiefs and the queen's parishes. But they had not acquired formal legal training or apprenticeship, but their relevance could not be overlooked, as few legal practitioners in the colony were only white people and had no knowledge of the local customs. The law that was practiced at the forts, castles, and were both naval and merchant laws, and they were purely on European laws. Let's have a look at the passage of the Legal Practitioners Ordinance of 1876 and qualifications for barristers and solicitors in the colony. In 1876, the Legal Practitioners Ordinance, Cap 8, was passed to regulate barristers and solicitors called in the United Kingdom, Ireland, and Scotland, and persons who had practiced as attorneys, those who styled themselves, those who had practiced as attorneys for 3 years in the colony to practice in the Supreme Court, the District Commissioners' Courts, and the Native Courts. Section 3 of the ordinance provided as follows. Quote, every person who has been called to the bar in England or Ireland, or admitted as an advocate in Scotland, or admitted as a barrister or advocate in the British colony or possession. B, every person who shall have practiced as an attorney, solicitor, proctor, writer, signet, or otherwise in any court in this colony for a period of 3 years, immediately preceding the commencement of this ordinance. Then C, every person who, being a barrister, solicitor, attorney, proctor, writer, to the signet, or other practitioners in any court in England or Ireland, or advocate in Scotland, or a barrister or advocate in any British colony or possession, shall have resided in this country for 1 year, and shall have practiced in some court therein for 6 months. So those who call themselves attorneys and never learned law, they were called as legal practitioners, and they had the opportunity to practice. Then the ordinance criminalized a person whose name was not on the roll of lawyers, but practiced law as a profession. The attorney, as contained in section 3 above, referred to cracks and the court interpreters who worked in the original, that is the colonial courts in Cape Coast, Accra, and Elmina, who prepared summonses, pleadings, and motions. And because of scarcity of British lawyers in the Gold Coast, the judges used them to run day-to-day court businesses. That is why even nowadays, you may see some interpreters and court clerks carrying themselves as lawyers. Because some people did that and they benefited. Then the scriveners and deed writers who were also admitted as legal practitioners were individuals who wrote deeds, leases, wills, conveyances, and contracts for mainly chiefs, traders, and their families. The merchant agents were the Europeans and African merchants who acted in courts for debt recoveries and commercial dispute, and had been in that business for at least 3 years. You know, debt recovery started long ago. So if you are lucky to have involved yourself in debt recovery before 1883, then automatically you became an advocate. As attorney, solicitors, or proctor, but did not have formal bar and appeared in the courts for others. The category of persons who described themselves as attorneys, solicitors, and barristers who had not acquired professional training were considered to practice law, where the person could prove that they had practiced in that capacity for 3 years, immediately before the passage of the Ordinance of 1876. The ordinance referred them as attorneys or native attorneys to distinguish them from barristers and solicitors from England, Scotland, and Wales. But both categories of professionals had the same rights before the courts. But they wanted you to know that you don't have a formal training, even though you are a legal practitioner. But they were given equal opportunity before the courts. Section 9 of Cap 8 was provided to prevent other people who were not recognized by the ordinance from practicing law in the colony. Section 9 provided as follows, quote, no person other than a legal practitioner enrolled under this ordinance shall act as a legal practitioner in any court, unquote. The Courts Ordinance of 1883 also created district commissioners' courts and native courts. The persons who appeared before these courts were persons enrolled under the ordinance for legal practitioners and had their names in the roll of lawyers. The interest of the Gold Coast people in becoming either barristers or solicitors increased, as a result of which some of them studied hard to become barristers and solicitors. The first lawyers from the Gold Coast traveled to England to be called to the English bar. And we all know that John Mensah Saba was the first person from the Gold Coast to be called to the Lincoln's Inn in 1887, followed by Francis Dove in 1889, then J.E. Kesley Hayford, 1886, then Henry Van Heen in 1901, J.B. Dankwa, and others, 1922. The law practice in the Gold Coast was not regulated. After the passage of the Legal Practitioners Ordinance in 1876, admission to the bar closed, except for those who were called to the English bar and applied to be enrolled by the Chief Justice in the Gold Coast. At that time, enrollment was the preserve of the Chief Justice. There was no General Legal Council, there was no such body. Non-British subjects or citizens of the Gold Coast who were barristers and solicitors were required to be resident in the Gold Coast for 1 year and had practiced for 6 months. The Legal Profession Ordinance of 1944 repealed the Legal Practitioners Ordinance of 1876, Cap 8. Now let's look at the Legal Profession Ordinance of 1944 and qualifications for barristers and solicitors in the colony. It is very, very interesting to note. The Legal Profession Ordinance of 1944 defined a legal practitioner as a person who had been enrolled as a barrister or solicitor under the ordinance. The persons who qualified to practice law as of right were those who were called to the Bar of England or Northern Ireland. The other 4 categories required some years' practice and examination by the Chief Justice, unless the Chief Justice directed otherwise that the person possessed a sufficient knowledge of the local laws and customs of the colony. So the power was given to the Chief Justice. Either you come and write examination, or you may be in the good books of the Chief Justice, and the Chief Justice may say, oh, as for you, you are well versed in the local customs. The first group was made up of persons who had been admitted and enrolled as solicitors of the Supreme Court of England or Northern Ireland and had been in actual practice as such for a period of at least 5 years. There was a clear distinction between barristers and solicitors. The second category consisted of any person who had been admitted and enrolled as an advocate, attorney, barrister, proctor, or solicitor of any court of civil and criminal jurisdiction in any British possession and had been in actual practice for at least 3 years. Then the third category of persons, we talk about those who satisfy the Chief Justice that they were fit and proper persons to be admitted and enrolled as legal practitioners. They for a period of 5 years with a legal practitioner and had passed the examination conducted by the Chief Justice. It meant that there is a lawyer, then you go to the lawyer. I want to be a lawyer. So what do I do? Then he enters into an agreement with you. I'm going to train you apprenticeship for 5 years. After the 5 years, you will go and sit for the Chief Justice examination. If you pass, you became a lawyer. So now I ask myself, if somebody is given the opportunity now, 5 years, to learn under the feet of my brother, Justice Kulendi, wouldn't that person qualify even to become a High Court judge? The Chief Justice had exclusive power to admit and enroll as barristers and solicitors of the Supreme Court upon an application made by a person who made the requirements of the ordinance. Section 3 of the Legal Profession Ordinance of 1944 on the power of the Chief Justice to admit and enroll qualified persons to practice law in the Gold Coast provided as follows. I just want you to understand, that is why I'm quoting. Quotes 3:1. Subject to the provisions of this ordinance, the following persons shall be entitled and to be admitted and enrolled as legal practitioners. That is to say, A, any person who has been called to the Bar of England or of Northern Ireland. That one, as of right, you come to Ghana, you start your practice. B, any person who has been admitted and enrolled as a solicitor of the Supreme Court of England or the Supreme Court of Northern Ireland and has been in actual practice as such for a period of not less than 5 years. So if you are a solicitor, you should prove that I have practiced it for 5 years and therefore I'm entitled to be enrolled. Then the C, any person who has been admitted and enrolled as an advocate, attorney, barrister, proctor, or solicitor of any court of civil or criminal jurisdiction in any British possession and has been in actual practice as such for a period of not less than 5 years. D, any other person who satisfies the Chief Justice that he is a fit and proper person to be admitted and enrolled as a legal practitioner. Then the E, any person who has served under articles for a period of 5 years with a legal practitioner and has passed the examinations prescribed by rules made by the Chief Justice. So the Chief Justice was examiner marker, and the person responsible for call to the bar. Then 2, every person applied to be admitted and enrolled under paragraph B, C, D, and E of subsection 1 of this section shall, unless the Chief Justice otherwise directs, satisfy the Chief Justice by examination or otherwise that he possesses a sufficient knowledge of the local laws and customs of the colony. So, apart from the persons who pass law as career, section 3(1)(e) of the Legal Profession Act of 1944 permitted articled clerks to enter into 5 years apprenticeship contract with a legal practitioner enrolled under the ordinance to be eligible to be admitted by the Chief Justice as a barrister or solicitor without being called to the UK bar after that person had passed an examination prescribed by the rules of court. There are legal luminaries and outstanding juries in the Gold Coast who became lawyers through apprenticeship routes. Notably among them is Sir Henry Kusi. There were other legal luminaries and outstanding jurists, including Justice Niyama Olenu and Ebenezer Akonjeyi, who did some of the articles in Gold Coast before completing abroad. So can we restore it? The essence of explaining the apprenticeship route to becoming a legal practitioner in the Gold Coast is that lawyers who were produced locally through this route were of the same status and equal intellectual power as those who had the opportunity to study abroad to become barristers and solicitors in England before being called to the bar in the Gold Coast. The power to strike off the name of a legal practitioner in the Gold Coast from the roll of lawyers as barristers and solicitors, which were kept by the Registrar of the Supreme Court, was exclusively exercised by the Chief Justice. So if you misbehave, the Chief Justice dealt with you. He had the power to strike off name of any legal practitioner from the roll on grounds that the legal practitioner had been convicted of a felony or any offense involving dishonesty or had been guilty of misconduct in a professional respect in the opinion of Chief Justice. So when we are talking about misconduct in a professional respect in the opinion of the Chief Justice, there is no definition. The Chief Justice could either suspend a legal practitioner instead of striking off his name from the roll of lawyers. The Chief Justice had the power to restore the name of a legal practitioner whose name had been struck off from the roll of lawyers or suspended from the roll of lawyers. The complaint procedure against a legal practitioner was ad hoc and exclusively exercised by the Chief Justice, as there was no regulatory body such as the General Legal Council. And whatever the Chief Justice considered to be misconduct was final. There was no bar association such as the Ghana Bar Association and the Law Society of Ghana. And there was no code of conduct. But what constituted misconduct was within the powers of the Chief Justice. The Legal Practitioners Act, 1958, number 10, was passed into law to localize legal training. That was where it was decided that let's legalize legal training through formal education. And further regulate the legal profession in Ghana, immediately after Ghana had attained her independence. The Legal Practitioners Act, 1958, number 10, amended the qualifications for enrollment of lawyers to a person with a law degree from a university approved by the minister and had completed a course of professional training at the Ghana School of Law and had obtained a certificate to that effect from the director of the school. The power to approve universities to award an approved law degree was given to the minister, and the minister was to exercise that power by legislative instruments. The act made the Ghana Bar Association the body responsible for disciplinary matters involving barristers and solicitors by setting up a disciplinary committee consisting of the chairman of the Ghana Bar and 4 other members of the Ghana Bar Association appointed by the Chief Justice to inquire into complaints of professional misconduct against barristers and solicitors and report its findings and recommendations to the Supreme Court. At that time, you will be reported to the Supreme Court after the findings have been made, adverse finding. The first time the Ghana Bar Association was given recognition as an association was by this 1958, that is number 10. The power to strike off the name of a barrister or solicitor from the roll of lawyers, or to suspend was transferred from the Chief Justice to the Supreme Court on an application by the Attorney General or on his own motion in a case where the person had been convicted of an offense involving fraud, dishonesty, guilty of professional misconduct after that person had been given a hearing. Hearing was mandatory. The subsequent amendments made the ordinance included the Military Advocate Ordinance, Cap 57, which regulated who could appear as advocates in military courts and provided that 7 military officers with some legal training appointed under the ordinance could usually appear for the prosecution or defense in courts martial. Quite often, the military, the laws that regulate them are quite different from all other people in matters involving military discipline. Even now, we have the court-martial discipline, then we have the court-martial general. Then you appeal to the court-martial court of appeal. Quite often people think that because the court-martial court of appeal is composed of 3 judges, either 3 court of appeal judges, 1 court of appeal, 2 high court judges, it is a superior court. It is a lower court because it is created by an act of parliament. And when 3 court of appeal judges sit in the court-martial court of appeal, 1 high court judge can supervise them by the supervisory powers of the high court. The subsequent amendments made to the ordinance included the military ordinance. So the Legal Profession Act number 22 renamed the Legal Profession Ordinance Cap 261 to the Legal Practitioners Act 1958 and further transitioned to bridge the law between Cap 261 and the new Legal Profession Act, Act 32. The Legal Practitioners Amendment Act 1958, that is number 53, was also enacted to address the requirements for non-citizens of the Gold Coast who required 1 year residence and 6 months practice to be enrolled as barrister or solicitors, to tighten them to allow only British subjects or citizens of the Gold Coast with residence requirements to promote Ghanaian interests. Let's look at the problems with legal education before independence. There were several problems associated with legal education in the colony, and a few of them will be discussed under this subtopic. The majority of the Gold Coast became legal practitioners after 5 years of articles with a legal practitioner and had passed an examination based on the rules of court set by who trained the person who had a propensity of compromising equality, compromising quality. Thirdly, the training and examination of the locally trained legal practitioners and those who trained abroad, including the white people, were based on English law, which did not consider the status of the Gold Coast and the customs of the people, who should have formed an integral part of the local legal system and methods. We all know that in 1876, the British, through the passage of the Judicature Act, handed over all their common law, determined by the Queen's Bench, King's Bench, Chancery, all of them to us as part of our law. That is why we still consider them as common law. But it is part of their customs that were passed on to us. Let's look at the legal training after independence. The Legal Profession Act 1960, Act 32, established the General Legal Council to be responsible for the organization for the legal profession, and in particular, for the organization of legal education and upholding standards of professional conduct. The General Legal Council was tasked with establishing a system of legal education and selecting the subjects in which those seeking to qualify as lawyers shall be examined. The General Legal Council improved legal education by first abolishing with the under-standardized colonial apprenticeship. So, 1960, it was abolished. But those who had the qualification continued to practice because laws are supposed to have prospective and not retrospective effect. The requirement to become a legal practitioner was not based on having a degree. Degree was not a requirement. And the acquisition of a certificate and diploma were enough. The majority of the pioneer students from the Ghana School of Law did not have diplomas and degrees, but were admitted to pursue law. You'll get several names, but I don't want to mention anyone. The Ghanaians who studied law and became solicitors or barristers from the United Kingdom before independence were called to the bar as of right. A reasonable number of the Ghanaians who studied law abroad pursued law programs with certificates and never acquired degrees, but were able to practice. I know one of them who had only diploma. He published and became a full professor of law. You may know him, Justice B.C. R.A.C. Crab. The practice of automatic call to the bar continued after independence until the General Legal Council introduced some local subjects, including constitutional law and legal system and methods, as a condition precedent to their call to the bar to help them to understand the domestic laws to make them relevant to the newly independent Ghana. The council provided core subjects for students seeking to qualify as lawyers to write and pass before proceeding to the Ghana School of Law to ensure that standardized, practical, and Ghanaian-focused training is taught. Core subjects that were taught include the law of contract, constitutional law, Ghana legal system and methods, criminal law, immovable property, law of tort, equity and succession, and jurisprudence. The subjects that were taught at the Ghana School of Law, which had the monopoly of legal education in Ghana, were company law and practice, alternative dispute resolution, legal accountancy and practice, law management, civil procedure, criminal procedure, law of evidence, law of interpretation and statute. Those who are in now, they are still examined on these subjects. The prescribed courses taught at the Ghana School of Law entitled the General Legal Council to award a qualifying certificate in law to partially fulfill the requirements to the bar, to the call to the bar under Section 13 of Act 32 for both students who qualify for enrollment. The irony is that you complete your LLB for 3 or 4 years, depending on whether you are fresh from SS or postgrad or you have a degree. Then you go to the law school for 2 years. You may presume that you should have been awarded a master's or even another degree, but they were awarded certificates. That is what we say award. Section 3 of Act 32 provides, quote, a person is qualified for enrollment if that person satisfies the council in respect of A, good character, B, the holding of qualifying certificate granted under Section 13. Then a person may be enrolled by the council if the council is satisfied that as to the good character of the person, as to the qualification to practice, and what have you. At the time the Act 32 was assented to on 12 January 1961, there was no requirement for a citizen of Ghana who had qualified for enrollment as a result of having been called to the bar in an analogous system to prove any other thing apart from requisite certificate until the Act was amended by paragraph A of the Legal Profession Act Amendment number 2, Decree 1967, NLCD 213. Hitherto, once you came as of right, then you were enrolled. But at a point in time, the law was amended that if you came to Ghana, then you must undergo 3 months training at the post-call. Even the post-call 3 months training was there until 2013. We had it until 2013 when it was changed from 3 months to 1 year. I was then a lecturer at the law school, so I know the transition. The automatic enrollment of citizens who were called to the bar in an analogous country was changed by the amendment that was introduced by NLCD 213. Presently, those who do their degree in law in Ghana and called to the bar in a common law country are required to complete a 1-year program to be taught and examined on civil procedure, criminal procedure, law of evidence, interpretation of these and statutes, and family law and practice. In 1971, that is where we are going to talk about the turning point. In 1971, the Act 32 was amended to make a degree prerequisite, that is, a degree approved by the General Legal Council, a condition for becoming a lawyer in Ghana. Paragraph B of the Legal Profession Act Amendment Number 2, Act 1967, NLCD 213. The NLCD 213 introduced Section 4 of Act 32, which provides that, quote, with effect from this first day of January 1971, a person is not qualified for enrollment under a provision of this act unless that person is a holder of a degree from a university approved by the council. So until 1st January 1971, those with certificates from other jurisdictions that they have been called to the bar, they came and did 3 months and they were called to the bar. But this law insisted that you must have a degree before you be called to the bar. Some of you who might have read this case, Ashley versus General Legal Council and Judicial Council, 2007-2008, one Supreme Court of Ghana law report. What happened was that Ashley came to Ghana as a lawyer, but without degree. And he was appointed as a magistrate grade 2. He was promoted to magistrate grade 1. But magistrate grade 1 was reserved for only those who have been called to the bar in Ghana. But because he was a lawyer, he thought he could. Then he was promoted to circuit courts. Still, he wasn't a lawyer, properly so called. Then he put in an application to be appointed as a high court judge, and somebody raised it. That actually, you came to Ghana after 1971, and you came without a degree, even though you are a lawyer, and therefore you should not qualify. The matter was heard by the General Legal Council. They ruled that Ashele was not a lawyer, and therefore his practice at the circuit court and magistrate grade 1, they were unauthorized. So he was asked to go and become a registrar. He said he wouldn't go. So he litigated up to the Supreme Court, but he lost. That the basic requirement was that you should have had a degree. So the introduction of degree is of recent event. It was introduced just in 1971. The lawyers who do not do their degree in law in Ghana and would like to be enrolled must add 2 more subjects. That is the post-court, legal system and methods, and constitutional law. So those who did LLB in Ghana went to Gambia, UK, and others, and they came back. They will do the 5. But if you schooled outside Ghana, you do the 5 plus legal system and constitutional law. The General Legal Council introduced additional subjects, interpretation of these and statutes, evidence, family law, and what have you, because they thought that there was a lacuna that needed to be filled. In 2015, the General Legal Council changed the 2-year program for persons with degree in law to 1 year to complete the 10 subjects within 1 year. That was where they failed. I was then the head of interpretation. About 50% of them failed. Not interpretation alone, all the subjects. Because it was a 2-year program, 10 subjects, and now they were to do all the 10 within 1 year. So at a point in time, instead of 1 year, it took some of them 6-7 years to complete. That was why we introduced something we call transition students. Now let's look at the basis for the change by the Legal Education Act, just of recent. There were demands by some Ghanaians to abolish the monopoly of the legal education in Ghana, which was operated by the Ghana School of Law, under the supervision of the General Legal Council. When the Ghana School of Law was established in 1958-59, it trained lawyers simultaneously with University of Ghana. At that time, University of Ghana had been set up. You will come and do the first degree, the BE, then you did the BL here, and you were called to the bar. So those who were here from 1958 up to 1967, they ran parallel. They never attended Makwala, including Justice Broby, Justice V.C. Arus, A.C. Crab, all of them. They did not attend school at Makwala. They did their school here. They did their bar here. So that is what is being restored, but with a difference. So at that time, those who went to the University of Ghana had both their degrees that entitled them to be called to the bar in that school. So when I was writing this paper, I called my good friend Justice J.C. Amonumoni, retired Justice of the Supreme Court, who is 91 years. And I asked him, JC, why did you do all your program at Legon? He said, I'm quoting him. Legon permitted us to do the bar. And if you went to the Makola, he said, Makola. What was Makola? The name alone was the meaning. So some of us decided not to go there. So we did everything here up to 1967. In 2012, when other universities, including both public and private, started producing lawyers, the Ghana School of Law did not have the capacity to admit all the students and introduce an entrance examination organized by the Independent Examination Committee. The IEC is a committee of the General Legal Council that is responsible for entrance examination and professional examination in the Ghana School of Law. Now, the Legal Education Act 2016, Act 1170, was enacted to break the monopoly of the Ghana School of Law to ensure that any person with a law degree who meet the requirements for admission is given access to the professional legal education. And during our time, during Justice Sophia, my brother Professor Kwame Jan, they were classmates, I know. My brother Justice Kulendi, my brother Kamo. At that time, the entrance was very, very difficult, how to get admission to the law faculty. At times, they would take 120, at times, they would take 90. After examination, competitive examination, then they selected 60, and that 60 went to the law school. So the Act 32, the new Act, says that we should abolish the monopoly. Let's give access to legal education in Ghana. So the Act established the Council for Legal Education and Training to regulate education in the country, and further to provide curriculum and students and standards for legal education. The universities that meet accreditation requirements shall be accredited to pursue the professional law course, which has a duration of 1 year, in addition to the Ghana School of Law, whose graduates will sit for a common examination organized by the National Bar Examination. Some of the courses that are taught had been transferred to the universities as taught courses, and they are law of interpretation of deeds and statutes, family law and practice, alternative dispute resolution, and company law and practice. So now we have the last batch in part 1 at the Ghana School of Law, because it has been offloaded from the university, from the Ghana School of Law to the faculty. And they call it taught courses. It is, we need another time to discuss whether indeed they are taught courses or not. How can you call a family law and practice a taught course? How can you call ADR and practice a taught course? The universities are now organizing pre-bar programs to cater for subjects that were taught at the Ghana School of Law and have been offloaded to the universities. The question to be asked is why the students who are attending the pre-bar program were not given the opportunity to gain admission to the Ghana School of Law to complete the 2-year program instead of spending 1 year for the pre-bar and further and another year for the National Bar Examination. This is a rhetoric question. Anybody can ponder over it, and you give answer that will satisfy your quest to acquire knowledge. The transitional arrangements were not managed well, and the students who are to do the National Bar Examination within 1 year are spending 2 years for. That is one for the pre-bar program, then another one for the examination, for the course itself. Now, let's look at the way forward. Chair-Dean. Now, the accreditation. Now, we have 19 universities producing Bachelor of Law graduates. Are we going to accredit all the 19? Even in Britain, how many of them have been accredited to run? Even the best schools, Cambridge, Queen's, King's, they don't run bar programs. So what are we going to do? We look forward. The accreditation to the universities is to operate the 1-year academic law practice training program shall be scrutinized to ensure that only the schools that will meet the accreditation requirements are accredited. The teaching faculty shall be one of the most important considerations to prevent situations where some of the universities will not get competent lecturers to teach and impact negatively on the performance of their students, even as at now. we know as a fact that there are some students at the Ghana School of Law who do one-on-one with some people who are not lecturers and do not qualify to teach at the law school. And some of them, they do it online with about 500, 600 followers. The physical infrastructure of the university shall be examined before only those who will meet the criteria are accredited to operate the program. Inasmuch as there should not be fetters on entry requirements of persons with the approved degree in law to legal education and training, sight shall not be lost on the fact that the program is an academic year, and where the universities do not have the required teaching faculties, it may take their students a number of years to pass the examination. Furthermore, the unaccredited tuition, which is expensive, and some of the facilitators do not qualify to teach the program at strict compliance with standards to produce lawyers who will be acceptable to the people of Ghana. Section 73 of the Legal Education Act, which gives power to the Council for Legal Education and Training, the power to prescribe rules to govern the receipt of the National Bar. So now, receipt for National Bar is to be determined. It has not been determined. As we have now at the Ghana School of Law, you have a right to fail 2 times. That is, to be in one class for 3 years. After 3 years, you will be withdrawn because you occupy space. But this one, they are not occupying any space. So do we limit them? Can they write as many times, 10 times, 15 times before they pass? So we need to take inspiration from the other professional bodies to prevent thousands of people who may not pass the examination within the prescribed time from continuing to resit until they pass. Conclusion. Dean, the true measure of a legal education system lies not in the number of lawyers it produces, but in the unyielding quality, integrity, and competence of justice itself. The history of legal training from the time of colonization through post-independence has been a continuous process of learning, adaptation, and reform to meet the needs of the people at any point in time. The Legal Education Act 2016, Act 1170, was also enacted to reform the existing legal training, which has been in existence for 60 years, with few modifications through amendments to the existing laws to expand access and modernize legal training. The success of this new legal regime will depend on uncompromising standards, rigorous accreditation of law faculties, robust teaching and physical infrastructure, fair and unrestricted receipt policies by the Council for Legal Education and Training and the National Bar Examination Committee that measure true practical competence rather than procedural attrition. The journey for legal education and training in Ghana has not been smooth, but we hope to arrive at a destination one day without problems that will call for another system of legal education and training to replace the current one within a foreseeable future. I'm praying that they will not fail when they write the examination. Once they write first, second, third, and they start failing, then there will be agitation. Let's change the law. Let's change the law. As we did 1 year in 2016, and it ended up with students that were given a name transitional students. The mantle falls on policymakers, regulators, academics, and other stakeholders in legal education and training to collectively build a legal education and training regime that will promote the rich heritage of our motherland and be able to compete with their counterparts in the other common law jurisdiction. The reform is a new beginning to ensure that legal training and education became more practical, inclusive, and accountable. The lady who introduced me, thank you for the kind words. And is it a poet or what, or whatever? I enjoyed. The first time I met him was Justice Brobe's book launch. That was where he introduced Justice Brobe as a person born from Asanwase, and he rose through the ranks to become a Supreme Court judge and had written several books. Congratulations. Thank you for the opportunity to take part in this meeting lecture. We should take it home. It is a food for thought. What do we do to ensure that the legal education we are pursuing promotes the interests of Ghanaians, and it will help build the capacity of students who seek to become lawyers. Thank you for that. Thank
Distinguished ladies and gentlemen, at this time I would like all of us to do one more big round of applause as we say a symbolic thank you to His Lordship, Justice Sir Dennis Dominic Ajay. He brought us a historic perspective and has put a lot to our thoughts as we look forward to seeing what the next phase of legal education and legal practice in this country will look like. Once again, we're very grateful to you, sir. Shall we do one more big round of applause in appreciation of His Lordship? And now, distinguished ladies and gentlemen, I'd like to welcome here Nehuma Japong. He is a member of the winning team of the 150th anniversary Supreme Court of Ghana Moot Court competition. He will introduce our next distinguished speaker. Please welcome him with another round of applause. In a few moments, we'll be getting into the much-awaited introduction of our next speaker. Before that, however, I would like to once again say a very big thank you to all the seasoned lecturers of this institution who are here to support. Some of them have had to take early leave because of commitments to lectures that are happening at the moment. And so at this time, I would like to say a very big thank you to Ms. Rachel Hazel. Shall we do a big round of applause for her? She's been here throughout. Also, Mr. Vitus Nganuma. Shall we do a big round of applause for him? We're very grateful to you. Also, ladies and gentlemen, a key member of the organizing team that has put together this maiden edition of the Distinguished Alumni Series. Dr. Fafa Delight Agweko, shall we do a big round of applause for her? Distinguished ladies and gentlemen, we're also glad to have the presence of the CEO of VRA, Engineer Kenzo. Shall we do a big round of applause for him? And once again, would like to say greetings to our friends who are joining us from various locations, especially through the live stream on the University of Ghana School of Law pages on social media. Once again, we're grateful to our very dedicated and distinguished sponsors whose belief in and of course talk about GNPC. We're glad to have the presence of Mr. Joshua Edem Homenu. He's representing the organization here. Shall we do a big round of applause? Attorney General is a practicing state attorney, Ms. Ama Asari Korang. Shall we do a big round of applause? Also, we are glad to have the presence of Edmund Diamond Addo, who's representing SIC Life Insurance Limited. Shall we do a big round of applause for? Once again, would like to say a very, very big thank you to all the friends from media organizations who are also here with us. And we are glad to have the presence of all these institutions joining us today. Of course, I would like to, at this time, say a very big thank you to the lead producer and a senior editor at TV3, who is in charge of New Day and many other news programs. The award-winning Roland Walker is here with us. Shall we do a big round of applause? Distinguished ladies and gentlemen, I duly acknowledge the presence of a Justice of the Court of Appeal of the Republic of Ghana, Justice Sophia Benasco Essa. Your Ladyship, we're very grateful to you for your presence here. And of course, the presence of these distinguished justices go to provide a lot of inspiration for the generation of students and young lawyers who are looking forward to making impact in the legal system in this country. Also, at this time, I would like to acknowledge the presence of Her Ladyship Justice Bertha in organizations who are also supporting us today. One of them is the Association of Customs House Agents, who are represented here by Mr. Philip Bedu Mensah. Shall we do a big round of applause? And so, ladies and gentlemen, now my pleasure to lead us into welcoming our next distinguished speaker for this maiden edition here at the University of Ghana School of Law.
Your Lordships, Justices of the Superior and other courts, ladies and gentlemen, it is my honor to read the profile of His Lordship Justice Emmanuel Yoni Kulendi, Justice of the Supreme Court of Ghana. Justice Yoni Kulendi, born in Wa, hailing from Isa in the Upper West region. Justice Yoni Kulendi's journey to the apex court of the land began in the classrooms of the Tendanba Primary School, the Experimental Primary School, and Wa Middle Day School. He proceeded to Wa Secondary School and completed his O-level and A-level education at Navrongo Secondary School and New Jobin Senior High School, respectively. It was at the University of Ghana that he earned his Bachelor of Laws, LLB degree, before proceeding to the Ghana School of Law and being called to the Ghana Bar in 1994. He would later add to his credentials a master's degree in international security and civil military relations from the Naval Postgraduate School in Monterey, California. Justice Kulendi cut his teeth in practice at the esteemed firm of Akufo-Addo, Prempeh & Co., where he undertook his pupillage and practiced from 1995 to 2002. In 2002, he founded Kulendi at Law, and as its founder and managing partner, grew it into one of Ghana's foremost law firms. At the bar, he built a formidable reputation as an access, among them, and with a kind permission, Felix Klomega versus the Attorney General and Ghana Ports and Harbour Authority, 2013-2014, One Supreme Court of Ghana Law Report at page 1. Sumaila Bible versus Adanu Dramani and the Attorney General, 2011, One Supreme Court of Ghana Law Report at 32. NDK Financial Services versus Yedom, 2007-2008, Supreme Court of Ghana Law Report at 93. And Hawa Musa against Fatih Musa, 2011-2012, 2 Supreme Court of Ghana Law Report at 819. Cases that have helped shape Ghanaian jurisprudence. Distinguished ladies and gentlemen, in May 2020, his distinguished career at the bar culminated in his elevation to the Supreme Court of Ghana, where he continues to serve with distinction. with cases like Ezwame Manan and the Attorney General, where Justice Yoni Kulendi questioned Parliament's legislative process and whether they had given the citizenry the chance to deliberate and give their feedback on Section 43 of the Narcotics Act. The School of Law is honored to welcome him home, and today, in a few minutes, Justice Kulendi will deliver a lecture on the architecture of effective justice, the stewardship of the bench, the advocacy of the bar, and the trust of the people. But before we welcome Justice Yoni Kulendi here, and with a standing ovation, we will take appellations, the Seperewa appellations from the legendary Openyi Osei Kranchi, the geologist.
Agona moya suntia menyum ye. Ablanwa Drew, His Lordship, Justice Emmanuel Yoni Kalandi. Ablanwa Drew. You didn't can you but was yo. Pa. Abaya Sadia Manchima. And the Pabian son and one fast one in Chima Siano. And tonight I told Safra, sir. I couldn't know any interest here. That Jenny does one. Nti adom ni nhyira onyame de apagya wo amo abedrum pempenso yi woni ya meche ne anya bia suama enchema nso anya mfaso ebele no ni ye esrem se jatai obele ni o aja minansa bele akoni ni ntinahia Eja kasao.
Oh, please kindly help me applaud Openyi. Openyi, that's it. Yamin Shrao. Openyi is a living example of Proverbs 22:29, which says, "Do you see a man skilled in his work? He will serve before kings. He will not serve before obscure men." That is skill we are celebrating. Openyi, God bless you. And for my colleague students here, it's an example to us, the way to go, mastery. May I also then, for brevity of time, say all protocols are duly observed, but even then I'll have to acknowledge one of my favorite teaching assistants who is in the house, Professor Kwame Jan. Let's give him an applause. And my brother Kabwa, for my lords and ladies, do bear with me if I want to set out the list of people I wish to commend. That will become my conversation. But I must say it's a singular privilege. It's a distinguished honor to return to this campus, the institution that contributed to my own understanding of what it means to be a lawyer. And returning to one's alma mater is always humbling because it reminds us that before we became judges, practitioners, or academics, we were students. Learning that the law demands hard work, the law demands focus, it demands integrity and intellectual honesty. And that is what I would like to underscore to my fellow students who I have the privilege of speaking to, because I can say without fear of equivocation that these values have come to constitute the core of my own journey. that has brought me here today. As Openyi acknowledged, I'm a simple Wa boy. Walked into this faculty in a class of 126 students. And as my brother Dennis said, and please, shall we acknowledge my brother Professor Dennis again? I mean, that was a lot of learning. And that's what you get when you bring characters like this to the podium. He just offloads. And thank you. And as he rightly underscored at the time, there was in the first year of this faculty a practice called baptism by fire. And lecturer after lecturer will remind you that even though you are here, stop telling your relatives and friends you are a law student, because you are not a law student until you have survived your baptism by fire at the FUE exam. And so we slept in the library. This was a restless place as professor after professor, teaching assistant after teaching assistant will start with a warning about baptism by fire that will cause some of you to perish or survive. And here was the practice. At the end of FUE, you return to this faculty and you'll see a list posted on the notice board as they did in our primary schools. And from 1 to 40 in order of merit, there will be a red line. And those 1 to 40 were those qualified to do LLB. Then from 41 to 60, there are 2 red lines. And that 20 are those who are qualified to do a Bachelor of Arts with a major in law. These 2 cohorts will take you automatically to law school. Anybody below the second double red line, you could go study anything on this campus, but not law. I mean, it was fierce. And so from day one, I mean, and somehow one day in the quiet, I don't remember what lecture it was and what came upon me, I stood up and called the attention of the class and said I had an announcement to make. We were fairly new and nobody knew the other. And so people were curious. Who is this guy? What does he mean? I said, I have an announcement to make. Attention. People gave attention, and then I announced with audacity, I don't know where I got it from, that listen, I want to put everyone on notice that this year, if the LLB class is reduced to 1, the class is full because I've taken it. I mean, the rest is history, right? But it's a testimony of what focus and determination will do. And so I want to entreat you, my fellow students who are part of this audience, for 45 minutes, focus and let the phone rest, let social media rest. Then you take in what you can take in. You can process it later. You can discuss it later, because we have made these very useful tools become distractions. I mean, my focus in lectures was always total, and it paid off. I think it was from that culture that Professor Jang identified me. I became his kind of younger brother, and we've always had that relationship up to today. And so to the theme of my lecture, conversation, which is the architecture of effective justice, it invites us to think of justice as an enduring structure. I believe the metaphor is particularly apt. A great building survives not because of the beauty of its facade, but of the strength of the unseen foundations that support it. Likewise, the justice system does not endure because of occasional landmark decisions or celebrated pronouncements. A system of justice endures because countless judges, lawyers, court officials faithfully perform their constitutional duties every day. Justice, therefore, is not an event. It is an institution. I therefore suggest to you that the architecture of effective justice rest upon three indispensable pillars. One, the stewardship of the bench. Two, advocacy of the bar. And three, the trust of the people. The Constitution itself leads us to this architecture. Article 125 declares that justice emanates from the people and is administered by the judiciary in the name of the Republic. Those words are profoundly significant. They remind us that neither judges nor lawyers own the administration of justice. Judicial authority belongs to the people, while the bench and the bar merely exercise it in trust for the people. Every judgment delivered and every submission made by a lawyer is therefore an exercise of the public trust rather than a private privilege. If justice ultimately belongs to the people, then the effectiveness of our justice system cannot be assessed by constitutional ideals alone. Judicial independence, the rule of law, and access to justice remain indispensable principles, but they must also find practical expression in the everyday experiences of those who come before the courts. Institutions are measured not only by the ideals they proclaim, but also by the outcomes they produce. The statistics from the current legal year provide an illuminating perspective. Ladies and gentlemen, between October 2025 and March 2026, Ghana's superior courts received 4,347 new cases and concluded 4,305 cases, leaving approximately 29,500 cases pending. Behind each of those pending cases stands a citizen, a family, a business, or a community awaiting legal certainty. Every file represents rights awaiting vindication. Every file represents obligations awaiting determination or disputes awaiting a peaceful resolution. When we speak of case backlog, we are therefore speaking not merely about numbers, but about people whose lives remain in suspense whilst justice takes its course. The distribution of these cases is equally revealing. The High Court alone received 2,854 new cases during the period and concluded 2,860, whilst carrying a pending caseload of 24,543 cases, representing more than 83% of pending cases before the superior courts. This confirms that every practitioner, what every practitioner already knows. The High Court remains the engine room of Ghana's judicial system. It is there that most criminal prosecutions commence, commercial disputes are resolved, constitutional issues arise for the first time, land litigation is determined, and countless citizens first encounter the formal administration of justice. Equally significant, however, is the fact that the High Court concluded slightly more cases than were filed during the reporting period. The numerical differences may appear modest, but its institutional significance is considerable. It demonstrates that despite mounting pressures, improvements in case management, technological innovation, and the commitment of judges and court staff are beginning to reduce rather than merely contain the backlog. Institutional progress is rarely dramatic. It is more often a product of steady and sustained improvement. Ladies and gentlemen, the appellate courts present a different but equally important picture. During the same period, the Court of Appeal received 1,214 appeals and concluded 1,195, while the Supreme Court received 279 new cases and concluded 250 of them. Their pending caseloads are presently at 4,501 and 454 cases, respectively. These figures should not be viewed as evidence of institutional failure. Appeals invariably involve more complex questions of law, extensive records of proceedings, and issues of wider public importance that necessarily require greater deliberation. They do, however, remind us that the timely administration of justice depends not only upon judicial diligence, but also upon adequate institutional capacity. That reality becomes even clearer when viewed alongside the composition of the bench itself. Ghana's superior courts presently comprise of 221 justices, made up of 142 High Court justices, 61 justices of the Court of Appeal, and 18 justices of the Supreme Court. These judges collectively shoulder responsibility for almost 30,000 cases. The figures underscore both the immense demands placed upon our courts and the remarkable commitment of those who serve within them. They also remind us that judicial independence, though indispensable, cannot by itself guarantee effective justice. An independent judiciary must also be adequately resourced, supported by efficient registries, modern technology, sound case management systems, and sufficient judicial personnel if constitutional guarantees are to become practical realities. Delay remains one of the greatest challenges confronting every justice system. Yet delay is seldom the product of indifference alone. It often reflects broader societal developments, such as expanding commerce, increasing constitutional awareness, population growth, and greater public reliance upon formal legal institutions. In that sense, a growing caseload presents both a challenge and an affirmation. It challenges the judiciary continually to improve efficiency, but it also reflects the confidence of citizens that disputes are more likely to be resolved through the courts than through self-help or extra-legal means. Ultimately, ladies and gentlemen, the stewardship of the bench demands far more than deciding cases. It requires safeguarding the legitimacy of the institution itself. Judicial independence protects not judges, but litigants, ensuring that every citizen, regardless of status or influence, may expect the law alone to determine the outcome of his or her case. Yet, independence must always be accompanied by impartiality. Justice must not only be done, but must manifestly be seen to be done. Public confidence is earned incrementally through every judgment delivered, every litigant treated with dignity, every advocate afforded a fair hearing, and every exercise of judicial discretion grounded in fairness and reason. It is these ordinary acts, faithfully performed, that ultimately sustain the architecture of justice. Now I turn to the advocacy of the bar. Ladies and gentlemen, if the first pillar of effective justice is the stewardship of the bench, the second is the advocacy of the bar, where most of you will belong. It is the relationship between the two is neither hierarchical nor adversarial. It is collaborative. The administration of justice is not the exclusive responsibility of judges. It is a shared constitutional enterprise in which judges and lawyers perform distinct but complementary roles. Judges decide only those cases that are brought before them, and only upon the facts established and the arguments presented by lawyers. The quality of justice, therefore, depends in no small measure on the quality of advocacy. That responsibility has never been more significant than it is today. The legal profession in Ghana has experienced remarkable growth over the past decade, as my brother, Professor Dennis, has enumerated. The expansion of legal education and professional training has enabled many more young men and women to enter the profession than at any previous time in our history. In 2025 alone, 961 new lawyers were enrolled as barristers and solicitors of the Supreme Court, bringing, though, the total number of lawyers enrolled since 1963 to 12,200. Yeah. These figures, though, deserve celebration. They represent greater access to legal education, broader opportunity, let me say growing access to legal education, broader opportunities for public service, and an expanding reservoir of legal talent available to serve the nation. They also demonstrate increasing public confidence in the legal profession as a vocation worthy of pursuit. That's why it's exciting that everyone seems to want to be a lawyer. It's a great endorsement to the profession. I thought for lawyers we should clap for ourselves. That said, numbers alone, though, do not strengthen the administration of justice. A nation is not better served merely because it has more lawyers. It is better served because it has better lawyers. The true measure of a legal profession, therefore, lies not in its size, but in its standards. I'll say this again. The true measure of the legal profession in Ghana will lie not in its size, not in the numbers of lawyers, but in the standards that we bring to the profession. Every generation of lawyers inherits the reputation of the profession built by those who came before it. Equally, every generation leaves behind a legacy that will shape public confidence for those who come after. The question, therefore, is not simply whether we are producing more lawyers. The more important question is whether we are producing advocates of greater learning, of greater integrity, and of greater public spirit. The advocate's first duty, understandably and of course, is to the client. Every lawyer is expected to advance his client's lawful interests fearlessly and with industry. But that duty is not absolute. It is qualified by an overriding duty to the court and ultimately to the administration of justice itself. This is what distinguishes advocacy from professional partisanship. The advocate is not licensed to win at all costs. He is an officer of the court. He owes a duty of candor to disclose binding authority, even where it undermines his client's case. He must never knowingly misstate the law, suppress material facts, or invite the court into error. His success must always be achieved within the discipline of honesty. That duty is especially important because judges necessarily depend on counsel. Our system is adversarial. Courts do not investigate cases or disputes independently. They rely upon advocates to identify the issues, marshal the evidence, and present the applicable law. Weak advocacy, therefore, affects more than the fortunes of an individual client. It impairs the court's ability to arrive at the correct decision and, by extension, the development of the law itself. Preparation, therefore, is not merely a matter of professional pride. It is an ethical obligation. An unprepared advocate wastes judicial time, prolongs proceedings, increases costs of litigation for clients and for the public. Conversely, careful preparation narrows issues, shortens trial, and assists courts in reaching sound decisions more efficiently. In a justice system managing thousands of new cases each year, the cumulative effect of professional diligence cannot be overstated. Ladies and gentlemen, every unnecessary adjournment avoided, every issue properly refined, and every authority accurately cited contributes, however modestly, to the timely administration of justice. The bar also bears a broader constitutional responsibility. Judges speak principally through their judgments. The Constitutional Convention and judicial ethics rightly require restraint in public discourse. Otherwise, my stomach is pregnant with comments for the two young men who came to speak about the pending bill. But if you have time, go read Dr. something Ofori versus the Attorney General on lawful carnal knowledge. Incidentally, I had the privilege of uttering the reasons in that dispute. And then, if I can take the opportunity, Professor, since this is an intellectual engagement, also to say that indeed morality has not just a place, but a very central place in the law. In legal theory, that whole notion of natural law, the jurisprudence that animates and drives it, is jurisprudence of morality, rightness, propriety, what is desirable for the human species. Even positivism, which reads the letter of the law, is underscored by the same underlying principles. And in the common law, when you talk about the laws of equity, fairness, rightness, justice, in fact, implied in the notion of justice itself is a moral concept. But that's a deliberation for another day, if you give me this platform. But let me be restrained as I have just admonished myself. The legal profession, therefore, occupies a unique position. It must defend the independence of the judiciary against unfair and uninformed criticism, whilst remaining equally willing to identify genuine error through reasoned legal analysis and respectful criticism. And you must have heard me on record say that judges, in my humble view, are not above or beyond criticism. We are trustees, and the masters have a right to hold a critical opinion of us. But what I say is that don't berate or insult judges for our service to you. I mean, fair criticism, however harsh, is permissible, and that is actually what will improve the quality of justice. It must defend, as in the bar, the independence of the judiciary against unfair and uninformed criticism, whilst remaining equally willing to identify genuine error through reasoned legal analysis and respectful criticism. Loyalty to the institution does not require uncritical acceptance of every judicial decision. People are entitled to be critical of what, that is what keeps us sitting up at night and reading and rereading and underlining every line that we author. Rather, loyalty requires fidelity to the principles that sustain the institution itself. And this, in my view, will be independence, accountability, and the rule of law. To the students who will shortly join our profession, permit me to offer this reflection. Your greatest contribution to the administration of justice will not be measured by the number of cases you win, the prominence of your clients, the size of your practice, or even the size of your pocket. It will be measured, in my humble view, by your reputation for integrity. I'll say that again. Your prominence will be measured by your reputation for integrity. And for Christ's sake, if you don't take anything away from me today, take this one and process and sleep through it. Courts may occasionally forget the arguments you advance, but they rarely forget the advocate whose word could always be trusted. And I wish you are a lawyer and you have a window into the conference room of judges, and you will see that this one is a revelation I'm giving to you. Yeah, the courts will occasionally forget the arguments you advance, but may rarely forget the advocate whose word could be trusted. The future of Ghana's justice system will therefore depend not only on the wisdom of its judges, but equally upon the character of its lawyers. For it is only when an independent bench is matched by an honorable and competent bar that the constitutional promise of justice will be fully realized. Now, I make a comment on the trust of the people. If the stewardship of the bench secures the integrity of our courts and the advocacy of the bar ensures the quality of justice administered within them, then the third and perhaps the most important pillar of our constitutional architecture is the trust of the people. This is no mere rhetorical flourish, ladies and gentlemen. It is the constitutional foundation upon which the entire administration of justice rests. As I have underscored from the beginning, Article 125 reminds us that justice emanates from the people. That proposition carries profound constitutional consequences. It means that public confidence is not simply desirable. It is indispensable. It means that public confidence is not simply desirable, but is indispensable. Courts possess neither the power of the purse nor command of the sword. Their authority ultimately depends upon the willingness of citizens to accept judicial decisions as legitimate, even where those decisions are personally unwelcome. A judgment is effective not because it satisfies every litigant, but because society retains confidence that it was reached independently, impartially, and according to law. That confidence must continually be earned by the courts. It cannot be demanded by judicial office, nor secured by constitutional text alone. It must be earned. It is built gradually through the daily conduct of judges, lawyers, and every institution that contributes to the administration of justice. Every litigant who leaves the courtroom believing that he has been heard fairly, every witness treated with dignity, every judgment delivered with clarity, and every proceeding conducted with transparency strengthens the bond of trust between the judiciary and the public. Conversely, every unnecessary delay, every unexplained adjournment, every discourteous exchange, and every perception of unfairness weakens this bond of trust. Public confidence is painstakingly accumulated, but remarkably easy to lose. Trust also depends upon accessibility. A justice system serves little purpose if citizens cannot meaningfully invoke it. Access to justice is not achieved merely because courtrooms exist throughout the country. It requires that justice be affordable, be understandable, and that justice be capable of being obtained within a reasonable time. A litigant should not be denied justice because legal representation is beyond his or her means, because court procedures are unnecessarily complex, or because years pass through before his dispute is determined. Equally important is the intelligibility of judicial decisions. Our judgments are not written solely for appellate courts or legal academics. They are written first and foremost for the people whose rights they determine. Every citizen whose liberty, property, or reputation is affected by a judicial decision is entitled to understand why he has succeeded or why he has failed. Clarity is therefore not merely a literary virtue. It is an essential component of procedural fairness. Ladies and gentlemen, it is encouraging that despite the considerable pressures confronting our courts, citizens continue to bring their disputes before them in increasing numbers, as the statistics show. That confidence should not be mistaken for complacency. On the contrary, it imposes a continuing obligation upon all stakeholders to ensure that the administration of justice evolves to meet the changing needs of our society. Technological innovation, improved case management, continuing judicial education, alternative dispute resolution, and sustained investment in judicial infrastructure are no longer matters of administrative convenience. They are imperatives. They are indispensable instruments for preserving public confidence in the rule of law. Again, to the students, permit me a final word. You enter the legal profession at a time of remarkable opportunity. Our profession is larger than it has ever been. Our jurisprudence continues to develop. Our constitutional democracy continues to mature. The responsibility of your generation is not merely to inherit these institutions. Your true responsibility is to improve these institutions. Master the facts as diligently as you master the law. Cultivate integrity long before you encounter the great ethical tests of your professional life. And there are many. Your opponent will reach you one way or the other. You will be tempted to compromise your client's case. The he life will cause you to want to go to the club, go to the joint, you don't review the brief, and walk into court carrying the destiny of a business, the destiny of a family, the future of their investment. You must master integrity long before you encounter these ethical tests that will confront your professional life like a storm. Learn not only how to persuade, but also when fairness requires a concession. Because sometimes you see the lawyer and you are troubled in your stomach why he's pushing this point, and we look at each other and we are disgusted, but you still have to maintain your composure. So that's why I start by saying you are not in there to win. You are in there as an instrument of justice to ensure that the outcome is fair, is just, is conscionable, and is equitable. And by the way, those are moral principles as much as they are legal principles. You can see that that thing is eating my skin, right? Remember that reputation is earned in small decisions long before it is tested by great ones. No wonder the Bible says, if you cannot be faithful in little, you cannot be faithful in plenty. Above all, resist the temptation for cynicism. And I see it among a lot of young people, not just lawyers, but our young people who seem to think that we don't have a country, we don't have a system, we don't have a future, and so they are looking elsewhere. If God wanted you to be American, Canadian, German, God would have landed you there. There's a good reason you are on this planet and in this country. Give up the cynicism. Persuade yourself you can make the society you have met better than you met it and pass it on to your children. Every generation inherits institutions and cultures with imperfections. The measure of professional character lies not in lamenting or fleeing these imperfections, but contributing to their reform and improvement. And that is my challenge to you. Ladies and gentlemen, institutions endure because successive generations choose to preserve them. Each judge, every lawyer, and every student inherits a justice system built by those who came before. Our responsibility is not merely to admire that inheritance, but to strengthen it for those who will come after us. That is true legacy. The architecture of effective justice is therefore not sustained by grand constitutional declarations alone. It is sustained by ordinary acts faithfully performed. A judge who delivers a reserved judgment on time, an advocate who candidly draws the court's attention to an authority adverse to his client's case, a registrar who treats every litigant with courtesy and efficiency, a witness who speaks the truth, and a citizen who leaves the courtroom convinced that although unsuccessful, he has received a fair hearing. These may appear to be ordinary acts, but they are the extraordinary disciplines upon which the rule of law ultimately depends. If the bench continues to discharge its stewardship with independence and integrity, if the bar continues to practice with learning, courage, and honor, and if together we preserve the confidence of the people in whose name justice is administered, then the constitutional architecture of justice will not merely endure. It will continue to inspire confidence, secure liberty, and strengthen our republic for generations unborn. Long live this faculty, long live the Republic of Ghana. I thank you for your audience.
Beloved in the law, good people of Ghana, I believe that today is already a resounding success which will be spelt out by the media to the rest of the country because we couldn't have asked for any better inaugural speakers. I know you all agree with me, and let's do that through applause. On one end, Lord Justice Dennis Ejay set us on a path to understand the foundations of the law in our beloved nation, Ghana, from that historical perspective and the kind of influence that our colonial masters have had on our legal system. And then on one side, we have Justice Lord Shiblioni Kulendi, who now is provoking our thoughts about the kinds of realities that are set before us and the kinds of realities that confront us on a daily basis, irrespective of where you find yourself on the ladder. We are grateful to the good Lord for giving us these two distinguished gentlemen who are alumni of this great faculty. And we are grateful for a concept such as this that definitely has come to stay. Shall we do one more big round of applause in appreciation? Once again, it is important to say thank you to all our friends from the media who are sending out the good word. And of course, once again, we're grateful to the various platforms, including our in-house platform that has streamed this live, and also to City FM and Channel 1 Television, to Star FM and GH1 Television, and Metro TV. Shall we appreciate them with a round of applause? At this time, it gives me great pleasure to welcome here another seasoned lecturer to do what is demanded of us as a people of tradition, and that is to give symbolic thanks. When you watch and observe, you'd realize that it is referred to as the vote of thanks or the note of appreciation. Please help us. Before he comes onto the stage, however, we'll do something very symbolic that will go to express that appreciation which we want him to accentuate. And that is to do symbolic presentations to these two distinguished speakers. At this time, I'd like to respectfully once again invite our Dean of the University of Ghana School of Law, Professor Peter Atudiwe Atupare.
So, distinguished ladies and gentlemen, we will say this is a token. When I began legal practice, a senior friend of mine said that if you see me and you can tell the price of my jacket, then the client should be able to be thinking about how much he should be paying. If you look at the depths of knowledge demonstrated here, and we are asked to pay, I'm sure the accounts of the law school will collapse. So it is not an attempt to pay, it is just a token of appreciation. So with the hand of applause, may we invite Justice Dennis. And we invite His Lordship, Justice Tioni Kulendi. Thank you, everyone. Thank you.
Thank you. And I believe that one more round of applause is in order. Lord Justices of the Superior and other courts of the Republic of Ghana, good people of Ghana, ladies and gentlemen, please help me with another round of applause as we welcome Mr. Kenneth Garte to say a symbolic thank you to all of us.
Thank you, Nathaniel. Thank you all. I have the duty of giving the vote of thanks. First, we want to thank the Lord Almighty for success in the planning and execution of our maiden Distinguished Alumni Lecture Series. We thank especially our Lord Justices Ajay and Kulendi for graciously accepting to share their thought-provoking insights with us on the maiden edition of this lecture series. Special thanks to our Lords and Lady Justices of our Superior and other courts and members of the bar who have joined us this evening. We're thankful to Dean Professor Atupari for the vision for this series. Special thanks to the alumni, faculty, and students committee ably chaired by Mr. Herbert Krapper and assisted by Dr. Fafa Agbeko. Yes, you know, when events start, there are people who have committee meetings and strategy. And so Dr. Fafa Agbeko, Ms. Phoebe Aite, Mr. Augustine Kidiso, and myself. We thank Ms. Susie Lamte, our school administrator, and the many administrative staff whose tireless efforts led to the success you see today. We also thank our past and current students who have assisted in this endeavor today behind the scenes. We are also especially thankful to our sponsors, Ali Nachia and Associates, GMPC, MPA, and Boston Energies. We thank GH1 TV, Channel 1 TV, City FM for the airtime to publicize this event. Now, finally and more importantly, we thank all of you, especially our alumni, our students, and others who have joined us today for this maiden event. Please do not leave. We invite everyone to the cocktail that follows afterwards. Use the opportunity to meet old classmates if you're alumni and network with colleagues and seniors here present. We would only ask that students please kindly remain within the auditorium while we usher out our speakers and our guests after the program. Thank you very much. And of course, thank you to Mr. Nathaniel Atto, our indefatigable master of ceremonies.
We're very grateful to you, Mr. Kenneth Garte. And ladies and gentlemen, I believe that the organizing committee deserve commendation. Shall we do one more big round of applause? The chairperson, Mr. Herbert Krapper, normally would like to be in the background, but let's give the credit where it is due. We started this acknowledging the strength and the authority of the Most High God, and it is just custom and important that we wrap things up, going to him to say thank you to him for giving us a successful program. In that regard, I'd like to welcome Musa Idrisu to help us with a prayer. Shall we welcome him with a big round of applause?
My Lord, may we be in a mood of prayer. Bismillahir Rahmanir Rahim. In the name of Allah, the most gracious, the most merciful. All praises is due Allah, the source of justice, wisdom, peace. We express our deepest gratitude to you, Allah, for bringing us together today in pursuit of truth, legal excellence, and community. O Allah, bless our distinguished guest justices of the Supreme Court, as well as all justices present here and members of the bench present here with us. Grant them continued wisdom, courage, and discernment as they uphold fairness and the rule of law in our nation. We ask you to bless our host, the Dean, also with our dedicated lecturers, faculty members, management, students, and alumni of the University of Ghana School of Law. Ya Allah, elevate this institution as a citadel of academic distinction, ethics, and service. Ya Allah, we extend our sincere gratitude and ask for your blessings upon the sponsors and partners of this event, whose generosity and support made today possible. Ya Allah, we mark this day, this first day of ever distinguished alumni lecture series. We pray that you make it a firm foundation for the future editions announced by our Dean today. Strengthen our alumni with the willingness, resources, and passion to continually return, give back, and build up the noble faculty. May the insights shared in these series light our professional path for generations to come. As we depart, we ask for the protection. Grant us all present here safe journeys back to our homes and families. Subhana Rabbika Rabbi Izzata Amma Yasifun. Wassalamu alaikum salim. Walhamdulillahi Rabbil Alameen. Amen.
Our brother Musa Idrisu, we are grateful to you. Ladies and gentlemen, shall we do a big round of applause? Before the very final elements of this evening's gathering, I'd like to respectfully ask that our friends who are handling still photography come to the center as we have a set of 5 quick photographs. Thank you very much. The first will be the panel on the stage, which has the Dean and our 2 distinguished speakers. Thank you. And on a very light note, these are the little advantages we enjoy when we stand here on the stage. Respectively, my lords, can I join before I invite?